hello, and welcome to the first entry of the year in our Orientation to Legal Research webinar series, U.S. Case Law Research. My name is Barbara Bavis. I'm the Bibliographic and Research Instruction Librarian here at the Library of Congress, Law Library of Congress. Say that 3 times fast. And before we get started, I want to note that I'm going to be doing my best to leave time at the end of this webinar to answer your questions. As I said, we have a lot to cover today, so I'm going to be moving at a pretty quick pace. If you do have any questions during the presentation, I ask that you type your questions into the chat box and send it to all panelists. If your chat box does not immediately show up on your screen, look to the bottom right-hand side of your screen. You'll see a button that looks like a cartoon talk bubble. That is your chat button. And if you click that, it should open up the chat window in your screen. If I don't get to all of your questions, please feel free to send your questions to the Law Library of Congress's Ask a Librarian service. The Ask a Librarian link will be at the top of every Law Library of Congress webpage. That's on law.gov, law.gov. We're also going to give you a link to Ask a Librarian on the last slide. Before anyone asks, we are making the slides available via PDF file transfer at the end of this presentation. So please stay to the end if you'd like to get a copy of the slides. If you have to leave us early, or if you're on a computer that doesn't let you download things, just let us know via Ask a Librarian, and we'll be happy to send you a copy of the slides as well. We are recording this webinar, and, barring any technical issues, how everything is now, barring any of those technical issues, we will make that recording available via Eventbrite. So if you did not sign up via Eventbrite, or if you had any issue with your email address that you used to sign up via Eventbrite, again, please feel free to send us an Ask a Librarian request for the recording as well. Okay, so let's get started. I always like to give people a little bit of an overview of what you can expect to be covered during a presentation. So this is my little overview. First, we're going to talk about the general basis and structure of the U.S. federal court system with a very, very brief look at parallel state systems. If I went too deeply into the state systems, we could be here all day. Each state has their own little quirk to their court systems, but we'll just touch on it a little bit later. Next, we're going to look to case opinions. What do we mean when we talk about case opinions? How are they published? What can you expect to find when you see a case opinion published in a reporter or a book or an online database? Then we'll move on to where and how to begin your case law research, focusing on using the information you have to find case opinions that you need or that are on your topic. We'll discuss both print and online materials that you can use to complete your research. And then finally, we'll talk about how to find records and briefs, or the documents filed by parties or participants in a case, as well as those produced by the court itself. So as you can see, lots to cover. Let's get moving. As you will have received in your Eventbrite reminder earlier today, we'll be using the case of Miller v. AT&T, 250 F. 3rd 820. And if none of that makes sense right now, don't worry, we're going to go into a breakdown of case opinion citations as well. I just wanted to let you know that's the case we'll be using. It talks about the requirements for leave under the Family and Medical Leave Act. But let's first talk about the U.S. court system generally, particularly the U.S. federal court system. U.S. federal courts have jurisdiction over, or the power to make judgments regarding, certain cases. In your daily life, you've likely heard the most about cases involving the U.S. Constitution, federal laws and treaties where the U.S. is a party, controversies between states, cases where the federal government is a party, or controversies between citizens of different states if certain requirements are met. If something falls under the federal court system, this is the general structure that you're going to see in the federal court system. Largely, it's made up of 3 parts. First, there's the trial court level. When we talk about the trial court level in the federal court system, we're typically talking about a U.S. district court or a U.S. bankruptcy court. There's at least one district court in each state, sometimes more than one, as well as one in the District of Columbia, Puerto Rico, the U.S. Virgin Islands, Guam, and the Northern Mariana Islands. There are also two special trial courts. The Court of International Trade addresses cases involving trade and customs laws, and the U.S. Court of Federal Claims deals with most claims for money damages against the U.S. government. So those are general, the courts that you're going to see in the trial level at the federal court system. At this level, cases are usually conducted with a jury and one judge, or maybe just a judge acting as the trier of law and fact. If you've ever heard of a bench trial, they're typically talking about when the judge acts as a trier of law and fact. They generally don't issue written opinions. We're going to talk about the few exceptions to that a little bit later on. And the court documents that you might be interested in are typically kept at the court clerk's office or the archives, the National Archives. Next is the intermediate appellate court level. When you hear about this level, you're typically hearing about the U.S. Court of Appeals. Sometimes that's also called a U.S. Circuit Court. And you'll see there, I've listed on the slide, there are 11 circuit courts. They are made up of groups of states, typically, and territories. There's also one for the D.C. Circuit, and then there's one for the Federal Circuit. The Federal Circuit has jurisdiction to hear appeals in specialized cases, like those including patent laws, cases decided by the Court of International Trade and the Court of Federal Claims. Generally, there's no jury. Instead, there's a panel of judges. Lawyers present written briefs and then have an oral argument before that panel of judges, typically three judges on a panel, and they present their arguments to the court that way. And then lastly, if you appeal from the intermediate appellate court, you're going to the court of last resort, which in the federal system is the U.S. Supreme Court. The approach is similar to what we've talked about already, except that the Supreme Court doesn't have the power, doesn't have to grant your appeal. So they actually have a pretty small percentage of cases appealed to them that they actually accept and try. Okay. Before we move on to more of the federal court system, I just want to touch on the state court system. While state courts might not have the same names for their courts, so you might not see district court, court of appeals, et cetera, Supreme Court, they do generally follow a three-tiered structure. So they generally have a trial court level, intermediate appellate court, and then court of last resort. At that trial level, sometimes you're going to see they also might have municipal or county courts that hear, for instance, ordinance violations or traffic violations. One thing I want to note on here is that there are 9 states that don't have an intermediate appellate court level. So if you're dealing with a state case or if you're researching a state case, you might want to check and make sure that your state has that intermediate appellate court level. All the state courts are going to have websites with a lot of great information, including court rules. Sometimes now they also print some of their recent opinions. So please feel free to check that out before moving forward in your state court research. All right, but let's talk about some of the basic tenets of our court system. So in the U.S., we have what is called a common law system, which is based on the idea of stare decisis. And before I go on, I have to say, for attendees that don't have a legal background, we in the law love to use Latin terms for things. I am terrible at pronouncing Latin, so please give me a little bit of grace. I'm trying my best. So common law has its historical roots in England. We kind of brought that process over, or that system over to early America and adopted it in early America. Stare decisis demands that courts depend on and adhere to principles of law expressed in prior court opinions. So when you hear the term precedent or precedents, we are talking about principles of law expressed in prior court opinions. So courts are trying to decide cases consistently with that precedent. All right. So to determine a rule in a case, they look to that precedent as long as the facts are substantially the same, regardless of whether the parties and the property is the same. So we have to review those prior opinions to determine what the precedent is, and then the court is required to follow that precedent. But we have to talk next, though, about what precedent the court has to follow. And when we talk about that, we're really going to be looking toward mandatory versus persuasive authority. And if you haven't heard about this before, don't worry, I'm going to go into it right now. Mandatory authority is kind of broken into two parts. There's vertical mandatory authority and horizontal mandatory authority. If something is considered mandatory authority, that means that it's precedent that has to be followed in the current court, precedent that must be followed. When we're talking about vertical mandatory authority, we're talking about the fact that lower courts have to follow the holdings of higher courts. So as you can see on this slide, I talk about how U.S. courts of appeals and district courts have to follow U.S. Supreme Court decisions. District courts have to follow U.S. Court of Appeals decisions and Supreme Court decisions. And we're going to talk in just a second about horizontal authority, but I just want to make clear. So vertical authority is if a higher court decided a certain way, you have to follow that. So courts of appeals have to follow Supreme Court, district courts have to follow Court of Appeals and Supreme Court. Horizontal is talking about within a circuit. So if you're in a circuit court of appeals, so let's say in our case, we're talking about a case from the Fourth Circuit Court of Appeals. If I'm in the Fourth Circuit Court of Appeals, I have to follow a previous opinion from the Fourth Circuit, from that same circuit. The only way that I don't have to follow a prior case from that same circuit is if there is an en banc review. Again, with the Latin, I'm sorry. En banc review. What is en banc review? It means that instead of a panel of, about 3 judges, which I mentioned before, in an en banc review, a case is heard by all the court's judges in that circuit. So all of that circuit's judges meet, and then they can overturn prior precedent. All right? So if there's an en banc review of a case, whatever that entire en banc panel of judges decides is the new precedent going forward, even if the case was decided a different way in the past. All right. I know that's a lot to think about. So we have mandatory authority. Typically, you're going to be talking about vertical, so lower courts have to follow higher courts' decisions. Horizontal means if you're in a court of appeal circuit, for instance, you have to follow prior precedent in that circuit unless you are meeting for an en banc review. All right. That's mandatory. That you have to follow. But what if you're dealing with a case, let's say, that was decided in another circuit but not in your circuit? That would be considered persuasive authority. Persuasive authority is precedent that the court could use as a guideline, but is not required to use as a guideline. It's not binding on the court, but it is entitled to a certain amount of respect and consideration. So, for instance, if the Sixth Circuit Court decided a certain way on a case that the Fourth Circuit hadn't heard yet, or a topic that the Fourth Circuit hadn't heard yet, the Fourth Circuit could look at that case opinion and then decide whether they wanted to follow that process in their own decision. Okay, so it's persuasive but not mandatory. All right, so in our example, let's talk about our example. In Miller, our case was heard in the Fourth Circuit Court of Appeals. And in the Fourth Circuit Court of Appeals, they have to follow opinions by the Supreme Court and previous Fourth Circuit Court of Appeals opinions. In the case of Miller, they are not meeting en banc, so they have to follow other prior Fourth Circuit cases. All right. So let's go back to our federal court system cheat sheet. In this, you'll see I've just added on mandatory versus persuasive authority onto the structure we already had. So typically, mandatory authority is going down, persuasive goes up. Also, persuasive is for Court of Appeals decisions not in your circuit. All right. So now that we definitely have these basics down, right? Everyone's got all of these basics down. Let's talk about case opinions. I like to first talk about what we mean when we say case opinion. A case opinion is the written explanation of the reasoning behind a court's ruling regarding the outcome of a case. They use facts of the case and apply past precedent to those facts. So typically, when you see a citation, you're seeing a citation to a case opinion. So the citation we gave you for Miller is the opinion from the Fourth Circuit in that Miller case. People get really confused because when they're watching things on the news can sometimes refer to an opinion, a ruling, a verdict, and it gets a little confusing about what those different things mean, if they all mean the same thing. They don't. A ruling or a verdict is the final outcome of a case, whether decided by a judge or a jury, that leads to orders telling the parties what to do. I like to kind of refer to a ruling or a verdict as the what. So what the outcome was, what the order, later the orders are telling the parties what to do. Instead, the case opinion is more like the why. So why did the court rule that way? Why did they issue these orders? What precedent did they use to come to this decision? When we talk about case opinions, we're generally discussing those issued and selected for publication by appellate courts, so that intermediate appellate court or the Supreme Court, rather than trial courts. And I'm going to talk a little bit later about why that is and how the publication process moves ahead. But first, I want to talk a little bit about just generally, if you go into a library, where can you find these case opinions? So the publication of case opinions. The books that case opinions are published in are called reporters. So if you hear a reference to a reporter, they're just talking about the book in which you can find the opinion you're looking for. In the federal system, when we talk about Supreme Court opinions, we're generally talking about United States reports, the Supreme Court reporter, or lawyer's edition. Those are just different reporters publishing Supreme Court cases. At the intermediate appellate level, we're generally talking about the Federal Reporter Series. We're now up to the third series, and you'll see that delineated by F3D for Federal Reporter Third. People sometimes ask, what is a series? And why does the publisher have different series of a reporter? The number of volumes being published in each series, they typically go up to 999 and then have to renumber. So if you're having a certain number of case opinions being published, you're going to end up getting to about 999, and then you're going to have to switch over to a new series. So that's why we are now up to the third series in the Federal Reporter. And then lastly, I want to talk about federal district courts. Most district court decisions are unpublished. but the few opinions that are collected in the Federal Supplement Series. So you'll see FSUP or FSUP 2D for the second series. In the states, case opinions are typically published in regional reporters, where they take up a region of the country with multiple states and publish all of the state case opinions from the appellate courts in those states. Sometimes also states will have their own state law reporters or case reporters. So you need to look to your state to determine whether there's a state reporter and then also which regional reporter they might publish in. And we suggest using our Guide to Law Online feature on our website, which is law.gov. It's the Guide to Law Online, and it goes for each state and gives you an idea of what's being published in each state and where you can find it online for free. So just a note from me to you, I'm a little biased because I help a little bit with that Guide to Law Online, but I think it's pretty helpful. And I've done a lot of talking up to this point about published opinions. And usually at this point when we're in person, I get a question about, well, if you are talking about published opinions, are there unpublished opinions? And the answer is yes. So give me just a moment to explain, because this can be kind of another layer on top of what you've already learned. Generally, when we're talking about published opinions, we're talking about opinions that a judge or a court has decided should be published in a reporter. So we just talked, let me go back, we just talked about those reporters. That's what they look like kind of on the shelf. You can see that picture there. So a judge has decided their opinion should be published in one of those reporters, and they generally decide to do that because it covers new legal ground. So it creates new precedent that people can then follow in upcoming cases. These published opinions can be used as authority. So when we talked about that, the different types of authority, you can use published opinions as mandatory authority as long as, of course, you're dealing with a higher court or you're dealing with a court in the same circuit. This is where it gets a little sticky. Unpublished opinions. And this is particularly challenging because you can find unpublished opinions in a published book, a published reporter. You can also find them published online. So let's make sure to take a step back and talk about what is an unpublished opinion. Unpublished opinions are not selected for publication by the judge. So even if the judge releases an opinion, they write an opinion in a case, they might not select it for publication. These unpublished opinions will be pretty clear from the front of whatever reporter you're using. They'll definitely denote whether opinions are published or unpublished. Generally, you're going to find unpublished opinions in the Federal Appendix or the Federal Supplement. So those are the two you generally find these unpublished opinions in. And the front of the Federal Appendix and the front of the Federal Supplement will denote how you can tell if an opinion is unpublished. These unpublished opinions generally cannot be used as mandatory authority. One thing I do want to note, though, is with the kind of advent of online publishing, some appellate courts in their local court rules will allow you to use some unpublished opinions as authority. So check your local court. So check, like, let's say if you were in the Fourth Circuit, like in our example, you want to check the Fourth Circuit's rules and make sure that you cannot use unpublished opinions for mandatory authority. The general rule, 85 to 90%, you cannot, but more and more, some of those appellate courts are loosening those rules and allowing some unpublished opinions to be cited as mandatory authority. All right. So let's talk about the citation. So in your email, your reminder email that we sent earlier today, you saw this citation to the Miller case that I've been kind of mentioning throughout the presentation. This is how you would cite a case opinion according to the Blue Book. Now, the Blue Book is what we lawyers use as the citation manual for legal items. So if I were citing a case, this is how I would cite it, and it's broken down generally in this way. First, we have the names of the parties, so the plaintiff and the defendant. So the parties here are Miller, which is just the person's last name, and AT&T, which is the company that she sued. Next, we have the volume number of the reporter, and then the reporter abbreviation. So I know if I were in a library, I'd have to look at the shelf and pick up the 250th volume of the Federal Reporter 3rd series. All right. The next number you see there is a page number. So first number is a volume number, second number is a page number. So I'd have to turn to page 820 of the 250th volume of the Federal Reporter 3rd series to find this case. All right. We also ask that people denote what court heard the case and when they issued their decision, or their opinion. So in this case, we're talking about the Fourth Circuit. The Fourth Circuit heard this case in 2001, or they issued their decision in 2001. All right. So this is the general layout when you're citing two cases using Blue Book citation. Next, if you were to pick up that volume off the shelf and turn to page 820, you'd see generally this page, although technically this is on page 821. The reason is because they started the party names on the bottom of 820, and they wanted to reprint them at the top of 821 so people didn't get confused about what case they were reading. So we're looking at the first page of Miller here. You can see the parties are listed at the top of the page. Next, there is the file docket number and the court name. So the court is going to give their own number to a case, and that number will appear here. It's usually called the docket number or the file number. And then the court that heard the case, and then the date that the parties argued the case and the date that the opinion was issued. So the panel of judges has to actually go back. They have to look at the case. They have to apply precedent to the case. So it takes them usually a couple months to put out the actual opinion. So that's why there's a little bit of a range of dates there. Next, after that, you are going to see a synopsis of the case or a summary of the case. If you are citing to a case, you cannot use the synopsis of the case as precedent. The synopsis is written actually by the editors of the reporter, not the judges themselves. So it's just to help you so you can get your bearings on what you're reading, but don't cite to this, cite to the actual text of the opinion. Next, you're going to see another thing that's created by editors of a reporter. They are called Headnotes. We're going to go really in-depth into Headnotes in just a moment, so I don't want to get too in the weeds here. But Headnotes are just short summaries of other cases. Short summaries of what the court decided and what they cited to for that proposition. So we're going to talk about it a little bit later, but this is just telling you kind of generally the different points of law in the case and what they cited to support those different points of law. Again, do not cite Headnotes as precedent. You have to actually cite the text of the case. After the Headnotes, you're going to see a list of the attorneys that argued the case, the judges that wrote the opinion, and then the text of the opinion. That text of the opinion is what you are going to cite for precedent. Now, I showed you the print volume, so what you would find in a library, but there are some free online options Please feel free to utilize these online options, particularly now when a lot of libraries are closed due to the COVID pandemic. These online resources are all free, and you should be able to find a lot of those federal cases that we talked about, the opinions to those federal cases on these websites. At the bottom of this slide, you'll see that I've linked you to one of our research guides, which is How to Find Free Case Law Online. And that's actually going to walk through some of these websites and tell you how to do your research on these websites, you know, the little quirks of each website, how to do a search, how to do a keyword search, how to do a search by citation, et cetera. So we're going to give you guys these slides at the end of the class. Please feel free to go to that research guide and check out how to do your case law research on these different free resources. Now, in the library, which unfortunately is not open right now, but hopefully after this pandemic is underway, is over, we can reopen. We do have some subscription resources. For those of you who are not in the DC area, I'd suggest looking to see if you have a law library near you that's open and see what kind of subscription resources they have. We have, when our building is open, we have access to Westlaw, Lexis, or Nexus Uni is the version that we have, and Bloomberg Law. You might also have access to FastCase, which is another subscription resource. If you can get access to one of these subscription resources, we strongly suggest it because they have more extensive collections of opinions than a free resource would. They also usually have links to secondary sources that discuss the issues in your case. So that would be helpful for you while you're doing your research. And they also have access to something called a citator. And I want to put a pin in that because I'm going to come back to what a citator is for those of you who have never used one before. Totally normal. In fact, spell check usually picks up citator as a misspelling. So we'll talk about what a citator is later. Just know that citators are usually baked into the subscription resources, whereas they usually aren't with the free resources. We'll talk more about that in just a moment. Okay, so we know the basis of the case law system. We know where we can find case opinions, but now we have to figure out a research plan. So where do we start to plan our research? Where do we find these case opinions that are helpful to us? And where you find these case opinions or where you start your research is largely going to depend on the information you already have in hand. So I like to break down this part of the presentation into 3 parts, depending on what information you already have, okay? So let me just list them here, and then we'll go in depth on each one of these in just a moment. So first, if you have citations to the United States Code, that's the statutes, the laws that are passed by Congress in the federal case or by your state legislature in the state case. If you have a citation to a code section or a statute section, we're going to probably want to look to an annotated code collection. And we're going to talk about that in just a moment. If you have citations to case opinions, so let's say you already have a citation to a case opinion that's on the same topic or a topic you want to research. If you have that, I'm going to strongly suggest you look to Headnotes and Citators. And I know I've already mentioned Headnotes and Citators. This is where we go really in depth onto what I'm talking about when I say those terms. And then finally, if instead you don't have a citation to anything, you just have a legal topic in mind. If that's the case, we'll then look to digests and keyword searches within databases, all right? If none of that makes any sense to you, don't worry, here we go. I'm going to go more in depth on all of those items. So what if all I have is a citation to a statute or a law created by either a federal or state legislature? If you have a citation to a statute or a section of the code, which means the same thing in this case, I'm going to strongly suggest that you use an item called an annotated code. These are collections of the statutes in either in the federal case passed by Congress or in the state case passed by the state legislature that have something called annotations added to the end of them. So it has the language of the statute, and then underneath the language of the statute, it has notes. These notes include citations to primary and secondary sources that cite to or talk about that section of the code that you're researching. All right? So if you're looking at a particular section of the code, for instance, let's use our example. So see at the bottom of your screen or your slide there, there is a citation to a United States Code section. And again, that's the federal code collection or the federal statute collection. You'll see that there is a title number and then a section number. If I were to look at that section number within Title 29 of the U.S. Code, I'd see the language of that section, and then underneath it, I would see citations to cases that cite to that code section. I'd see secondary sources, so articles or books that talk about that section of the United States Code. Sometimes I even see regulations that might interact with that section of the code. So there's lots of really helpful items in these annotations that can get you started on your research and point you toward other resources that you might want to look at. This is a really great time saver. You get multiple citations to look at and consider when you're doing your research. When we're talking about the federal code, when we're talking about the United States Code, there are two main types of annotated, or two forms of the annotated code. There's the United States Code Annotated, or USCA, and I actually took a picture of this. This is from the reading room. They are the maroon books at the bottom of your slide. And then the United States Code Service, which is the black books at the top of the slide. Just by two different publishers, and they have different annotations based on the secondary sources published by those two publishers. All right. It's a great place to start because you might want to read a secondary source like an article or a book on the topic to kind of get your feet wet with regarding to that topic rather than looking at sometimes the highly technical statutory language. This is what a page out of the annotated code looks like. This is from that USCA, United States Code Annotated, the maroon books from the last slide. And I've actually turned to the end of the Miller case. And you'll see here, I'm sorry, I've turned to the end of the statute that was considered, sorry. I've turned to the end of the statute that we cited here. This statute was also cited in the Miller case. So I've turned to the end of the statutory language from Section 2612. You'll see up here Title 29, Section 2612. And then you'll see a table of contents down here below. This table of contents kind of organizes citations to cases that cite to this section of the code. All right. So they created this subject arrangement of the case citations, and they've kind of given them a general subject index. So if you were looking for instance, if you were interested in care for relatives, the leave requirements for care for relatives, which is kind of in the middle of that notes of decisions table, you could turn to that section, and it will have citations to different cases that touch on leave for care of relatives. I've kind of highlighted one of these one of these case opinion citations. So you can see there on the right-hand side, This citation provides a summary of the facts of the case being cited and includes the court's decision in that case, and then the citation where you can find that related case in a reporter. So if you were interested in the description of this case, you could look up the actual case opinion by turning to, and I'm just looking at the citation here in the middle of in the kind of bottom of the screen. It's pointing me to volume 144, Federal Reporter 3rd Series, page 151, if I wanted to see the actual case being summarized here. Okay. This can be really helpful. So if you have a topic of interest, you can look up that topic and then see all the decisions that the editors of this annotated code think are relevant to that topic. All right, so annotated codes. But what if instead of having a citation to a code section, I have a citation to another court opinion? So I have, let's say, one good case on my topic, and I want to see if there's other cases out there that also deal with this topic. What we would suggest you use is a citator. See, I told you to put a pin in that. Here's what a citator is. Case citators provide a list of opinions that have cited to or discussed your case. So they can include two main areas of inclusion here. They can include information about whether your opinion of interest has been subsequently upheld or overruled by other courts, and whether that is true simply of a part of the case or of the entire case. So a citator helps you determine whether later cases that have cited to your case of interest have weakened or entirely overruled a legal issue that was touched upon in your case opinion. All right. So a lot of times you're going to hear someone refer to a case as good law. And what they're generally referring to is whether the legal topics in your case have been overruled or upheld in subsequent cases. If they've been upheld in subsequent cases, then your case is still good law. Does that make sense? Next, the other thing you might want to consider when you're using a citator is the citator can provide information about other subsequent citing cases that dealt with the same issue. So whether or not they really talked about your case or discussed your case in depth, it's nice to have citations to other cases that also deal with your topic of interest, all right? So they might just cite your case in a long citation of support, but it might still be helpful to look at that case because they still discuss your topic of interest. Generally, citators, because so much work is put into creating a citator, you can only imagine editors have to go through cases, look at the cases that case cites, see whether they uphold or overrule those cases that they cite, et cetera, et cetera. There are actual people, actual editors doing this work. Because of that, publishers want to charge for their citators. So you're not going to find citator information, full citator information available online for free. You can find, I call them citator-like options. So Google and Court Listener, which are two of those free resources I had on the free resources slide, both of those have citator-like features where they will keep a list of cases that cited to your case as long as those cases are also in their database. And then you can usually link off and read those cases within either the Google or the Court Listener database. But they're not going to really talk about, they're not going to go in depth into the treatment of your case by those subsequent cases. They're just going to have usually a list of cases that cite to your case, and then you kind of have to determine whether they upheld it or overruled it. The subscription options, though, will actually give you a lot more information about how those subsequent cases dealt with your case. And those, again, because they want to charge for all their work that they're doing, are typically in subscription options like Westlaw, Lexis, Bloomberg, and Fastcase. So that, again, that's why while we're not open right now, I strongly suggest checking with your local law library and seeing if they are open and if you're able to get access to these resources, these subscription resources through your library. For those of you who are lawyers, you might also want to check your bar association. Sometimes a bar association will also provide subscription access to one of these subscription options. Okay. In addition to citators, we also suggest you look to headnotes of a court opinion. And here's an example of the Nexus Uni or Lexis headnotes for the Miller case. And if you want to zoom in, if you hover over the slides, you'll see on the left-hand side, there's a zoom in and zoom out button. They look kind of like a magnifying glass, so feel free to zoom in if you want to. Headnotes provide short descriptions of legal issues addressed in a case, and they appear before the text of a case opinion. Again, these are written usually by editors for, Lexis, Westlaw, et cetera. Headnotes are arranged hierarchically and thematically. All right, and what do I mean by that? What I mean is, think of an idea funnel. So big picture topic ideas are at the top of that funnel, and you winnow down more and more to the most specific idea within that topic. So for example, in my Lexis screenshot, at the bottom of that screenshot, you can see there is a big topic area, labor and employment law, and then it goes down to leaves of absence, family and medical leave, and then it goes down to leaves of absence, and then from leaves of absence, it goes down to family and medical leave. So you're getting from the big picture idea further and further down to your most specific topic within that big picture idea. Right? The reason you're going to be most interested in these is because they are subject areas, and so you're looking at a specific subject being touched upon in this case. And when you're dealing with West also assigns a key number to each headnote, and that key number can be used across West publications. So you can actually look up that key number and then see if there are other cases that also have that same headnote within their case. So if they also touch on that same specific issue within their case. So that's why having a case can be very helpful, a case opinion, because you can look to the headnotes, see the specific topics of interest within that case, and then you can use the headnotes to find other cases that also deal with that topic. All right, you can use that headnote across other cases. All right, we're getting there, so stick with me. We're almost there. Last option. What if you don't have any citations? You don't have a citation to a statute. You don't have a citation to another case. You just have a topic of interest, and you just want to see how courts have dealt with that legal topic. Okay, it's possible. Don't worry. Don't lose hope. What we would suggest doing is searching court opinions via Headnote, and you can do that in a digest. If you've ever heard of digest before, that's where I'd suggest you start. So if you haven't heard of digests, digests are print resources, and I've got a picture of what they look like in print at the top of this slide. They use the hierarchical and thematic structure of headnotes to classify case opinions by subject. So in a digest, you'd be looking for the headnote of interest, and then under that headnote, it's going to list the cases that cite to or whatever item you're looking in, the statutes, if you're looking at a statute digest, that cite to or that have that headnote within them. Let me do that one more time because I think I got a little confusing. Each headnote in a digest includes a list of case citations, and those case citations are then further arranged by jurisdiction and court. And then each of those case citations includes or speaks to the subject of that headnote. All right. So this is a way to take a topic and then find the cases that have that topic within them. One thing I want to note when you're doing this research, there are different digests for different date ranges and jurisdictions. So if you've never done any kind of digest research before and you're in a library looking at the books, please feel free to ask your librarian and they can kind of get you situated of where you want to be in those digest volumes. I've also included an example of a digest, a kind of online digest, and this is the West key number system. And these are as if you had the books. They break it down by those big topic ideas, and then you can open them and then drill down within those big topic ideas to find the specific headnote of interest. And then if you're using, let's say, Westlaw or Lexis, they will then link you to the cases in their database that discuss that headnote. All right. So the digest is kind of the thing that keeps the headnotes so that you can search by headnote rather than searching by case. All right. If you don't have access to a law library or a subscription database, you might instead have to search by keyword. You can always use one of these online databases, particularly those free ones I listed, to perform a keyword search. The librarian nerd in me tells you first to look to the help feature of whatever database you're using, because that help feature is going to have kind of tips for you about how to set up a search that gives you the resources you're really looking for. You might want to use, let's say, a Boolean search operator. So you want things that mention one keyword and another keyword. You might want to use a wildcard. So if you're dealing with a topic and you want to use the plural, the past tense, if you're dealing with a verb, et cetera, you might be able to use a wildcard so that you're searching all of those forms at once. And a big one for me, if you can find it, is the proximity search. Sometimes, particularly if you're looking for a person, you don't know if they're going to put the last name first or the first name first. If you have the ability to do a proximity search, you can tell the database, I want these words to appear within a certain number of words of each other, whether or not it's, first or second. So, for instance, if you wanted to search my name, it'd be Barbara Bavis, and a proximity search would find it even if it was Bavis, Barbara. All right, but check your help features, and they will help you as to whether or not they have these search operators. All right, I want to be sure I get to this. I know I'm nearing the end. I'm going to hurry, I promise. How do you make sure that your case is still good law? You do that by looking to the citators and particularly to these kind of citator flags that you see on the left-hand side. So as we discussed, you're going to have a whole list of opinions that cited to or discussed your opinion of interest. But what if you want to see at a glance, did these subsequent cases treat my case well? Did they uphold my case? Did they not? Did they overrule my case, et cetera? You can do that at a glance by the citator flags that you see on the left-hand side of the screen. You can also do that by opening the citator and seeing the treatment of your case, so how cases, whether they upheld or overruled your case, whether they discussed your case in depth or not, how many paragraphs did they use to discuss your case, which headnotes are in your case, and then you can search for headnotes that are used in other cases as well. And then finally, the courts that are citing to your case. So In our case, we're in the Fourth Circuit, so we're going to be most interested in subsequent cases from the Fourth Circuit or from the Supreme Court. As you can probably tell, red usually means you're overruled. Yellow usually means parts of the case were overruled, but parts of the case still stand. And then green, or sometimes blue, usually means that you're good to go. Everything in your case is still upheld, is still good law. I know I talked about a lot today. Don't worry, we're going to give you the slides at the end. I'm going to hurry so we could do that. But here are some other research guides you can use if you forget everything we talked about today. All right, I want to quickly talk on records and briefs. So we talked about records and briefs a bit. Records and briefs are the documents written by the attorneys or the pro se parties that are filed with the court. They are also documents produced by the court itself. So if you're interested in seeing, different orders in a court case, or maybe a complaint or a motion filed in a case, there are options for that. In the Supreme Court, there are many online options. You can pretty much find records and briefs from 1999 to the present. I've given you the different links there. The Supreme Court website now has their records and briefs from 2018 to the present, so feel free to check that out. If you need something pre-1999, you'll likely have to either use a subscription resource or go into a library to find a print resource. We are a Supreme Court depository library, so when we reopen, you are more than welcome to come in and look at our Supreme Court records and briefs collection. You can also use the link that I've given you there to see if there's a Supreme Court depository library that's closer to you, because they are kind of studded throughout the country. If you're dealing with a federal case that is from that intermediate appellate court or a district court, you will likely have to use PACER. There is a charge for PACER, 10 cents per page and a cap of $3 per document. But just so between you and me, they will waive that fee if you're under a certain amount each, I think it's quarter. So check the PACER website. It's easy. I have my own PACER account. It's easy to sign up, and then you can look up records and briefs from those trial level and intermediate level courts. Also, consider talking to the clerk of court. The clerk of court usually only charges for their copying costs, like their paper and their mailing costs. So that can be a low-cost option as well. All right, I'm nearing the very end. So what I'm going to do is I'm going to open it up for questions. I'm also going to do the file transfer. So a transfer window is going to show up on your screen. Don't close it. And you'll be able to download the slides from that box. Hold on just one moment and let me upload it here. All right. So all you have to do is click on the file name and then click download to see it. And while you guys are doing the file transfer, I am going to look at questions. If I go a little quiet, don't worry, I haven't left. I'm just looking at questions. For those of you who have to leave us, thank you for coming. And please fill out the survey. So when you close the window, a survey should open in a pop-up window. We actually do look at those survey responses, so please fill out the survey if you have a moment. And I thank you for coming today. So let me look at these questions and see if there's anything I can answer. Thank you for coming. All right, let me see. Oh, I do see a question. Who decides if a decision should be published or unpublished? That usually falls to either the judge, if there's a singular judge, or the panel of judges, if it's in one of those intermediate appellate courts, whether or not the decision is a published decision. And again, just to go over that one more time, the reporter that you're looking that decision up in will typically give you a note letting you know how to tell if a decision is published or unpublished. When you're dealing with the Supreme Court reporters and the federal reporters, federal reporter first through third, those are generally going to be published opinions. It's when you get into the federal appendix and the federal supplement that you have to kind of keep an eye out as to whether it's published or unpublished. Thank you guys so much for coming. If I didn't get to your question, please feel free to use Ask a Librarian. Anne is very helpfully putting the Ask a Librarian link in the chat. We are recording the webinar, and if everything goes to plan, we're going to be sending you an email via Eventbrite to all the people who attended with a link to the recording, and then you can access the recording from there. If you weren't able to get a download of the file, again, please feel free to ask us via Ask a Librarian. Also, feel free to ask us for the recording if you don't think you signed up via Eventbrite. And thank you guys so much for attending. I really appreciate it. Hope you learned a lot today. It looks like a couple of you in the chat said you did, which is great. And please come for our next Orientation to Legal Research webinar. It's going to be on federal statutes, and it's going to be in February. Anne has likely already given you the Legal Research Institute link. That's where you're going to find the registration information for that. We haven't put it up yet, so don't worry, you're not missing anything. But in just a couple days, we'll be putting the registration link up for the next class. Thank you so much, and please fill out that evaluation survey for us. I really appreciate it.